for all of us here at the Center for Human Rights. It's the first time that the World Moot has been fully online. And it's not only an exciting endeavor, but I suppose in some ways, it's also a way in which moots are progressing overall. Before we begin, I would like to call on some of our partners and our directors to say a few words of welcome to both teams that have qualified for these final rounds. First of all, I would like to kindly call Professor Claudia Martin, who is the co-director at the Academy on Human Rights and Humanitarian Law. Professor, please go ahead.
Hello, everybody, and good morning from very early Washington, D.C. I am very glad to be here once more together with the Center for Human Rights at the University of Pretoria and the Office of the High Commissioner for Human Rights at the United Nations to co-sponsor this wonderful program, the Nelson Mandela World Human Rights Moot Court Competition. The Academy is very happy and delighted to be part of this process. We know that this has been a very complicated year for everybody, but we want to congratulate Eduardo and our colleagues from the University of Pretoria for being able to carry out this competition virtually and with all the different challenges that has been that they have faced to make this a very successful program. As you know, the Academy of Human Rights and Humanitarian Law sponsors the Inter-American Moot Court Competition. We have been doing this for more than 25 years, and we are now also in the process of deciding whether or not our competition will be virtual or online. The most important thing, and I think that this is the conclusion that we have to get from this year, is that as human rights lawyers, we have been very resilient. We have been able to carry out our activities, continue to learn for the students who are here today, and also continue to promote and protect human rights. So congratulations to the two teams who made it to the final. We know that it's a tremendous effort and a tremendous achievement to make it here today. So congratulations, everybody. And again, a great pleasure to be here representing the Academy of Human Rights and Humanitarian Law. And I have been asked to say a few things in Spanish for the teams who have come and participated from Spanish-speaking Latin America. So I'm going to switch for a few minutes. Quiero decirles a todos buenos días desde Washington, D.C., muy temprano en Washington, D.C., pero quería estar presente en representación de la Academia de Derechos Humanos y Derecho Internacional Humanitario hoy para felicitar a los finalistas de la competencia Nelson Mandela, la competencia mundial en Derechos Humanos Nelson Mandela. Para la Academia es un gran honor todos los años copatrocinar esta competencia en colaboración con nuestros colegas de la Universidad, del Centro de Derechos Humanos de la Universidad de Pretoria y la Oficina del Alto Comisionado para los Derechos Humanos de Naciones Unidas. Sabemos que este año ha sido un año muy difícil para todos, pero como decía en inglés, y me parece lo más importante de resaltar, también hemos demostrado que tenemos una gran capacidad de resistencia, de esfuerzo y una gran capacidad de lograr nuestros objetivos a pesar de todas las dificultades que se han presentado. Así que felicitaciones a todos los que compitieron este año, a quienes vinieron y participaron de América Latina. Siempre para nosotros es un gran placer saber que los equipos de la región tienen el compromiso de seguir aprendiendo sobre derechos humanos y de participar en esta prestigiosa competencia. Felicitaciones a todos, muchas gracias a los colegas de la Universidad de Pretoria y los dejo en las manos de Eduardo y creo que el profesor Bill Joven. Gracias a todos. Thank you so much to everybody. I leave you in the hands of Franz Bill Joven.
Thank you, Professor. Professor Felion?
Thank you very much, Claudia. Thank you, Eduardo. Good morning, welcome, good afternoon, wherever you are, good evening even. So thank you for joining us. I think we all know that COVID-19 has made this, the 12th Nelson Mandela World Human Rights Moot Court Competition, something quite different. The organizers have decided, however, that we will not cancel the event. We will change its format. So ordinarily, we would have been together in the Palais des Nations in Geneva at this time. We would not have been connecting from our living rooms or our offices or our studies from places across the world. Also, ordinarily, we would have done this, all of the rounds, in a 1 week period around 18 July, which is obviously the time when we commemorate the birthday of that great human rights icon, Nelson Mandela. But extraordinary has its advantages. The advantage of doing this virtually is that, in a sense, the courtroom today is open to a broader audience of people looking in from live stream and from Facebook, we hope. Extraordinary also has its advantage because today, although we're not doing this around the 18th of July, we're doing it on International Human Rights Day, the 10th of December. And that really highlights the essence of what this competition is all about. It is about the values and the provisions that have been influenced by this very important milestone, the Universal Declaration. So the students this year obviously looked at a number of issues from a human rights point of view, looking at environmental degradation and how a human rights perspective can be useful, and looking at new technologies and how we understand the impact on human rights of these technologies. But let me say, as far as 2021 is concerned, we are optimistic that we will be back in the ordinary. In terms of the mode, we will hope to see this happening in person. In terms of the place, we will hope to see it in Geneva as in the past. And in terms of the time, we would like to see it on the 16th to the 22nd of July 2021. The only shadow we think that COVID-19 will still shed over us would be in respect of the hypothetical, that without giving you too much of a preview, the hypothetical will at least be done in the context and in the shadow of COVID-19. That is the hypothetical for 2021. For me, though, the main thing is to say a few words of thanks, and I do it now so that we can end with the announcement of the winners. No thank you words will be required at the very end. So very briefly, to all our participating universities, participants, faculty, members who supported the teams, we really acknowledge that you are the heartbeat of this competition. To briefly explain the competition for those who are not so familiar with it would be to use the idea of a pyramid. At the base of the pyramid, we have all the universities in the world that sent in memorials, written arguments, and from these are then selected the 10 best from each of the UN regions. Let me just say, despite the challenges of COVID, we had a very good spread of universities sending in their memorials. The region that had sent the most was the Asia Pacific, and the second most was Africa. And the countries from which most of these memorials came were India and Nigeria. Now, after this has been assessed, the next layer of the pyramid is that the preliminary rounds take place. That leads to the quarterfinals, the semifinals, and eventually the pinnacle of the pyramid, where we are today, the final rounds. I think it's good just to remind us about the 8 teams that emerged as the quarterfinalists in our preliminary rounds. 3 teams came from the Asia Pacific region, the University of Malaya from Malaysia, the National University of Singapore from Singapore, and Amy Institute of Law from India. 2 universities came from Latin America and the Caribbean, and those were or are the Pontifical Catholic University of Paraná in Brazil, and they participated actually in English, and Universidad Católica São Pablo, specifically Unidad Académica Regional Conchabamba from Bolivia, and they participated and were the winners in the Spanish rounds. From Africa, we had 2 universities emerging through, and that was Strathmore and Kenyatta, both in Kenya, and from the West European and other, 1 university, the University of Oxford in the United Kingdom. So congratulations, thanks to those universities. The second group that I would really sincerely like to thank are those involved in the assessment of the memorials, the judges in the preliminary rounds, often many hours of listening to very interesting arguments. Thank you to everyone involved. The drafter of the hypothetical case, I think the students found it a very quirky, interesting case. Dr. Thompson Kenyatta has been doing us the favor of devising these very cutting-edge sets of facts, and I would describe them as hovering between the harrowing and the humorous, and I think he found a good balance to keep us all interested in this set of facts. Our thanks also obviously go to the judges in the final rounds. You'll be introduced to them more fully in a few moments. Thank you very much for adding luster to this occasion. Our partners, as Claudia mentioned, first of all, there is the Office of the High Commissioner for Human Rights, in particular the Human Rights Council branch and people involved. Thank you for your support. Thank you also, Claudia, from the Washington College of Law, American University, and particularly the Academy on Human Rights and Humanitarian Law for your involvement and support. Then, not to forget the core team in the center. Claudia mentioned already Eduardo Capapello. It is not just today, I can assure everyone, it was really a year-long endeavor in this particular circumstance, a year-long endeavor of keeping committed, keeping dedicated to this task at hand. We really, really commend, acknowledge, and congratulate Eduardo for the excellent work in bringing us to this end point after a year of very intense hard work. He was assisted by Anna Kartunian with social media work and a whole team at the center. We have Carol Viljoen, we have Yolanda Boysen, and many others. My sincere thanks as the director of the center go to all in the center that had made this possible. And lastly, just from my side, also our financial partners, the donors. We have the European Union to thank through the Global Campus of Human Rights. The Global Campus of Human Rights is a network of universities that present master's programs in human rights and democratization in Africa across the globe. The Center for Human Rights at the University of Pretoria is fortunate to be one of those coordinating universities involved in this network called the Global Campus of Human Rights, supported by the European Union. I also thank the Swiss government through its permanent mission to the United Nations office in Geneva for its support not only this year, but on a number of occasions. With those few words, thank you to everyone. Thanks to everyone also who are present today, and good luck to the teams. Thank you.
Thank you very much, Prof. And I think with that, we'll introduce the judges in the final round. I'm sure that both teams are excited, and you will be interrogated, so to speak, by some of the best legal minds. So in no particular order, I'm going to introduce Judge Ivana Jelić. Judge Jelić is a judge of the European Court of Human Rights, who between 2013 and 2015 was the chair in international human rights law at the University of Montenegro. Judge Jelić has also served as a member of the United Nations Human Rights Committee between 2015 and 2018. Secondly, we have Judge Raul Pangalangan, who will serve as the presiding judge. Judge Pangalangan is a judge of the International Criminal Court. He is also a former dean of law of the University of the Philippines, where he taught constitutional law and public international law. Judge Pangalangan is an author and contributed to the comments on the Rome Statute of the International Criminal Court. Our third judge is Professor Veronica Gomez. Professor Gomez is the president of the Global Campus of Human Rights and also a professor at the University of San Martin. Between 1998 and 2009, Professor Gomez was a principal specialist at the Executive Secretariat of the Inter-American Commission on Human Rights of the OSS in Washington. Our fourth judge is Professor Manfred Nowak. Professor Nowak is a professor of international law and human rights at the University of Vienna, and also director at the Ludwig Boltzmann Institute of Human Rights. Professor Nowak was the United Nations Special Rapporteur on Torture from 2014 to 2010. He was also most recently the lead author in the United Nations Global Treaty on Children Deprived of Liberty. And I'm sure that all of you, most of you, if not all of you, know that Professor Nowak has published extensively in the area of human rights, politics, and public law, with over 400 books and publications. And finally, we have Professor Christoph Heyns, who is a member of the UN Human Rights Committee since 2017. He recently adopted, as many of you also commented during your arguments, recently adopted General Comment Number 37 on the right of peaceful assembly. From 2010 to 2016, he was the UN Special Rapporteur on extrajudicial summary or arbitrary executions. He is a director of the Institute for International and Comparative Law in Africa and professor of human rights law at the University of Pretoria. So that is your very esteemed panel of judges. And with that, I am going to hand over the proceedings to the Judge President, Judge Pangalangan of the ICC, to take us over.
Thank you so much, Eduardo. We will now proceed with the oral arguments for this morning. Can we then hear from the first speaker for the applicants?
Thank you very much. Judge President, Your Excellencies, may it please this honorable court. My name is Eugene Kanyugo, and I am deeply honored to appear before you alongside my co-counsel, Ms. Mariam Malik. We rise on behalf of the applicants in this matter and intend to take the next 30 minutes to make our submissions. I shall take the first 16 minutes to guide this court on the preliminary issues of jurisdiction and admissibility, as well as the merits of the first and second claims regarding the federal law on pesticides and the federal law on blindness. Thereafter, my co-counsel shall take 13 minutes to submit on the remaining two claims on the federal law on education, as well as the opposer legislation. We reserve 1 minute for rebuttal. With the permission of the court, I wish to proceed.
Yes, please proceed.
The applicant submits itself to the jurisdiction of this court owing to the fact that the respondent state is a party to the THHR Convention, the substantive law of this court, and further accepted the jurisdiction of the court as evident from paragraph 5 of the record. Regarding the first admissibility issue of standing, it is our submission that the applicant possesses the requisite locus standi to submit any matter before this court. As the record indicates at paragraph 5, any person or non-governmental organization enjoying observer status with the THHR Commission has legal standing before this court. It is therefore indisputable that since MDC, the applicant in this matter, enjoys such observer status pursuant to paragraph 15 of the record, this court's requirements on legal standing to represent the poor victims have been met. Proceeding on to the issue of exhaustion of local remedies, we submit that all available local remedies were exhausted in accordance with Article 56.5 of the African Charter on Human and People's Rights.
Counsel, may I interrupt briefly? When you say exhaustion of local remedies, are you referring to the remedies within UP or within IP?
We submit that these are the local remedies within the respondent state of UP.
But Council hasn't well, to start with, hasn't UP already withdrawn from the THC union? And why don't we start with that?
Thank you, Your Excellency. Due to the fact that the territorial dispute over the state of IP is yet to be submitted to the International Court of Justice, as evident from paragraph 27 of the record, the exhaustion of local remedies would remain unavailable, Your Excellency, owing to the fact that the local remedies regarding the fourth claim before this court, that is the opposer legislation, could not be exhausted, as the Constitutional Court of UP was unavailable and ineffective to the applicants on the following two grounds. First, the Chief Justice's statements at paragraph 28, and second, the jurisdictional impasse caused by the territorial dispute over the state of IP, which addresses your question, Judge President. Your Excellency, in dealing with this first factor on the Chief Justice's statements, according to the African Commission's decision in the case of Article 19 versus Eritrea, a remedy can only be considered to be effective where it offers a reasonable prospect of success, which Your Excellencies, the Constitutional Court of UP could not. As the record indicates at paragraph 28, the Chief Justice made statements to the effect that despite numerous attempts by the victims seeking redress from this court, the federal laws were there to stay. And Your Excellencies, the Constitutional Court of UP was the only court with exclusive jurisdiction over human rights violations. And therefore, in the Chief Justice's own words, any attempts seeking redress from that court amounted to spitting in the wind and would always come right back in the applicant's face. Your Excellencies, these statements indicate the applicant's predetermined fate were they to turn to this court, as it presented no reasonable prospect of success, and therefore any further claims before it would undoubtedly be fait accompli. Although such statements, Your Excellency, cannot be taken on their own to prove the ineffectiveness of the court, as the European Court of Human Rights decided in the case of Van Oosterwijk versus Belgium, for as long as such negative statements are combined with other factors, the ineffectiveness of such remedies will be proved. For this reason, the other crucial factor before this court is the territorial dispute over the state of IP, as indicated at paragraph 27 of the record. On the basis of this political situation, the Constitutional Court of UP disavowed its jurisdiction over the claims regarding the federal law on education. Given the Declaration of Independence of IP, the court refused to address any other claims arising from the state of IP, and as such, there was no available court in the respondent state to remedy the applicant's claims until this dispute was submitted to the ICJ and resolved, a matter which remains pending. Your Excellency, all factors considered, the applicants are in a state of limbo, where on one hand lies a judiciary giving enough signs that it cannot grant the applicants the justice they deserve, while on the other is a jurisdictional impasse, giving the same applicants the denial of access to the very courts they are expected to turn to first, which is the very reason we pray this THHR court be seized of these matters.
Counsel, that judicial statement about that matters arising in IP are outside UP jurisdiction. Doesn't that also form a recognition by the legal system of UP that IP is already a separate entity? And if that is the case, then it might, the separate identity of IP might work for you in your favor for exhaustion purposes, but it won't work in your favor for jurisdiction purposes, because then the violations would have been committed in IP, and IP has now declared its independence, no longer part of the union, and therefore outside the jurisdiction of this court. Can you address that point, please?
Thank you, Judge President. And I do note your concerns. However, Your Excellency, due to the fact that this dispute, as evident from paragraph 27 of the record, was yet to be submitted, the Constitutional Court would not be able to decide that IP was independent, and this decision is left to the International Court of Justice. However, even if the International Court of Justice were to find IP independent, this court's jurisdiction would still be retained to address human rights violations before it, due to the fact that human rights treaties, such as that guiding this court, can be applied extraterritorially, where a state is found to exercise effective control and authority over individuals outside its physical or spatial territory. Therefore, Your Excellency, since such personal authority is evident from the respondent state of UP's police officers acting in IP, as well as the implementation of the federal government's laws in the state of IP, even after IP's declaration of independence, there is no reason why UP should not guarantee the human rights of citizens in that territory and be held responsible for the resulting violations. Proceeding to the merits of the first claim regarding the federal law on pesticides, it is our submission that the FLP violated the minimum core of the applicant's right to food and subsequently the applicant's right to lead a dignified life. Article 11.2 of the ICESCR, which the respondent state is a party to as evident from paragraph 2 of the record, establishes the minimum core of the applicant's right to food as the fundamental right of everyone to be free from hunger, especially where a significant number of individuals are deprived of essential foodstuff. The Committee on Economic, Social, and Cultural Rights, in its general comment number 12 on the right to adequate food, has similarly established that a violation of this obligation may occur through the denial of food access, whether proactively or through legislation. Your Excellencies, following the federal law on pesticides ban on the only affordable pesticides, the record at paragraph 14 indicates that the majority of IP's citizens suffered from starvation and malnutrition as a result of the shortage of food sources and pest plagues in the respondent state. But despite the fact that all other pesticides in UP were only available at 5 times the price of the banned pesticides, the state enacted this ban, leaving its poor citizens starving and unhealthy, an unforgivable violation of the minimum core obligation on the state to prevent hunger and allow citizens to lead a dignified life. Your Excellencies, the respondents may seek to legitimize this ban based on the intention to safeguard the environment. But even in seeking legitimate aims, such as environmental protection, the Inter-American Court has stated in its 2017 advisory opinion regarding state obligations to the environment that environmental obligations are based on the primary duty of due diligence. As evident from the record at paragraph 12, the respondents enacted this ban without any due diligence assessment of the ban's effect on human citizens, or any further steps to mitigate the devastating effects once the state was made aware of the effects by MDC through its reports at paragraph 14 and appeals by the applicants to the Constitutional Court at paragraph 16. Your Excellencies, it may be easy to commiserate with the state and its intentions in this matter, but we remind the court that the presently starving victims continue to suffer a dehumanizing...
Counsel, just one comment. You can elaborate on the balance. You mentioned an advisory opinion of the Inter-American Court, and you're expressing the point of view of your client. But could you elaborate on the balance between the two rights, the right to food and also the right to a healthy environment, to which the Inter-American Court also refers to in the advisory opinion that you so aptly quoted? Could you elaborate on that?
Your Excellency, the Inter-American Court, in its advisory opinion, has also stated that the human person is meant to be the primary subject of such aims, such as environmental obligations, and therefore the right to a clean and healthy environment, though not stated in the THHR Convention, must prioritize the protection of human life and dignity, as well as other rights in the Convention. But despite this obligation, the respondent's federal law on pesticides undoubtedly prioritized the place of non-human entities at the expense of its own citizens. Therefore, Your Excellencies, the victims in this matter suffered a dehumanizing affront to their life and their dignity as a result of the respondent's own undoing, unless something is done. Proceeding to the merits of the second claim regarding the federal law on blindness, it is our submission that the federal law on blindness, and specifically its coercive measures, violated Catalia Rosario's right to be heard under Article 12 of the Convention on the Rights of the Child, and consequently failed to obtain the free and informed consent required for such coercive medical treatments by Article 25D of the Convention on the Rights of the Persons with Disability, which the state is a signatory to, as evident from paragraph 6 of the record. Your Excellencies, had the respondents cared enough to seek the views of the child on this matter, they would have understood that disability is not inability. As the record indicates at paragraph 25, the respondents forced Catalia to comply with the measures under the FLB and its coercive medical treatments in a bid to cure blindness. And furthermore, without her participation in her individual healthcare, the state made no attempt to seek her free and informed consent to this treatment as required by Article 25D of the CRPD. Your Excellency,
Counsel, can you address the point that Jessie was being required to register for some of these therapies for the unborn child? What rights are you invoking any rights for the unborn child, Counsel?
Yes, Your Excellency, it is our submission that Article 12 and the free and informed consent under Article 25D of the Convention on the Rights of Persons with Disability was similarly violated on the part of the unborn child due to the fact that the views of the child must be considered either directly or through the representation of the child through the parents, Your Excellency. However, this coercive...
Counsel, excuse me, when you say directly, what do you mean?
Directly, Your Excellency, applies to Catalia Rosario, who is of the age of maturity, or sorry, Your Excellency, the age of maturity for views to be sought. However, Your Excellency, in this matter, due to the fact that this is an unborn child, the views of the child and the consent should have been sought from Jessie Rosario, who is the representative of her unborn child. Your Excellency, under no circumstances is a state allowed to impose coercive treatments, save for the mental or communicable diseases as established by the Committee on Economic, Social and Cultural Rights in its general comment number 14 on the right to highest attainable standard of health, which blindness is definitely not. In conclusion, the state is speaking from both sides of its mouth, touting this measure as one...
Counsel, you'll have to wind up within 1 minute. Please proceed.
Thank you, Judge President. In conclusion, we submit that the state here is speaking from both sides of its mouth, touting this measure as one meant to allow children and blind people live full lives, all the while treating them as second-rate human beings who need to be fixed forcefully, a fault which we pray this court remedies today. Thank you, Your Excellencies, and I now yield the floor to my co-counsel to address the merits of the third and fourth claims.
Thank you, Counsel. We will now hear from the applicant's second counsel.
May it please this honorable court, my name is Maria Malik, co-counsel for the applicants in this matter, and I shall be addressing the merits on claims C and D before this honorable court, as well as submitting our prayers. Regarding claim C, we submit that the FLE violated the applicant's right to freely manifest their religion, as the FLE was disproportionate and unnecessary in a democratic society. Your Excellencies, Article 12.3 of the THHR Convention, which is evident from paragraph 5 of the record, is a substantive law that guides this court, provides that limitations on the manifestation of the right to freedom of conscience and religion may only be imposed for a legitimate and necessary purpose that is proportionate to the rights of others. We submit that restrictions imposed by the FLE were disproportionate to the rights of the applicants. Your Excellencies, in the case of Yaya Axa versus Paraguay, in 2005, at paragraph 145, the Inter-American Court expounded on the principle of proportionality and concluded that the burdens imposed by restrictions must not be excessive in relation to the objectives of those restrictions. Furthermore, the availability of alternative options is also one of the relevant factors in assessing the proportionality of a restrictive measure. This has been recognized by regional human rights courts, such as the European Court of Human Rights in the Hatton case, for example, in 2003 at paragraph 127, where the court identified the obligation of states to minimize interferences with rights by seeking alternative solutions and by generally seeking to achieve their aims in the least onerous way as regards human rights. And so the question begs, Your Excellencies, were the limitations imposed by the FLE?
Counsel, I'm sorry to interrupt, and also I failed to press the unmute button. But when you say that there are less restrictive measures, can you give us an idea? Isn't it that the measures taken by your own offered test of proportionality? I think if you make that argument, then you have the burden of telling this court that less restrictive measures would have worked, and that these measures would burden less rights and still achieve the statutory purposes. Can you give us an idea of those possibilities?
Certainly, Your Excellency. As we can see from the record at paragraph 7, UP has outstanding information technology and artificial intelligence industries. Given this, we propose that a less restrictive measure that the respondent state could have taken would be to introduce within legislation a limited use of facial recognition technologies, which can identify even those who have a facial covering. Your Excellencies, this law would prescribe strict limitations as to how the data collected may be used, thereby ensuring no misuse of this technology would occur. And as we can see from the record at paragraph 23, given the sporadic violence within public schools, there must be a way to identify individuals, to completely put an end to violence within public schools, but most importantly, to protect the students. We submit that this would be the least restrictive measure and therefore the most proportionate way. Turning to the merits of Claim D, we submit that UP Police's use of force violated Cartalia and her friends' right to humane treatment. Your Excellencies, Article 5.1 of the THHR Convention states that every person has the right to have his physical, mental, and moral integrity respected. In the 1990 decision of Baldeón Garcia versus Peru, where the Inter-American Court was interpreting the same substantive law that guides this court, it was held that effects on the mental integrity of persons who are not immediately proximate to the events in question can still be seen as a violation of the right to humane treatment. Now, Your Excellencies, the legal standard drawn from this consists of two elements. The first is the effects on the victims, and the second is the closeness of the victims to the circumstances that caused those effects. closeness to circumstances can be established considering key factors. One factor can be drawn from prevailing jurisprudence in the Inter-American Court, such as from the cases of Mejias versus Venezuela or Baldeón Garcia versus Peru, where the emotional ties to the next of kin appear to be the determining factor. However, Your Excellencies, in situations where advanced technologies are used, a crucial factor to consider would be whether this technology is a mere instrument such that actions are completely controlled and responses felt by the persons controlling the technology. In the present case, Your Excellencies, the first element of effect was satisfied, as seen from the record at paragraph 31, where the effect of the PTSD from UP Police's brutally callous use of force was felt by the applicants, leaving them mentally traumatized. The second element of closeness to circumstances was embodied through Cartalia and her friends' complete control over the robots and their immersion in the protest, which both demonstrate their undeniable proximity to the protest itself. Therefore, the actions of the robots, Your Excellencies, could not be differentiated from the actions taken by the children, and the responses to those actions were felt by the children.
Counsel, excuse me, but don't you think you want to have your cake and eat it too in this situation? They have complete control over the robots, over the holograms, and therefore it's almost like them. They're the ones actually speaking, but they are actually very safe from any physical attack. So, for me, don't you think that that the physical safety that this technology gives to the speaker is a benefit for sure, but don't you think that it can benefit them in terms of their physical safety, but legally, for purposes of showing that there has been for instance, a violent dispersal of protesters? What we have here is just like a virtual dispersal, that the speakers were not physically harmed in any way. So my question, counsel, is the nexus between the violation and the purported victims. What the victims suffered was not any physical attack, the way we are familiar with in violent dispersals of protests. And don't you think that the injury here is rather attenuated and rather forced? Please.
Your Excellency, we acknowledge your concern. However, we do urge this court to take cognizance of the fact that we are now in a digital era of human rights. Therefore, the use of emerging futuristic technologies must be given due weight, especially in determining whether a person's right to have their mental integrity respected has been violated. Your Excellencies, it is imperative that there is a way to hold states accountable for such conduct, as just because the person who was not physically present in the protest, it does not necessarily mean that there was no violation of their right to humane treatment. Your Excellencies, this only...
Counsel, you started your argument referring to jurisprudence in the inter-American system about the principle of proportionality. And this is also very relevant to the question of the precedent of this court. So could you refer to your argument in light of the principle of proportionality that you mentioned yourself, in connection with another argument? Could you continue, but also taking into account this perspective?
Your Excellency, with regard to proportionality, the use of force by UP police could not have possibly been proportionate, as it was not the minimum extent necessary, as is mandated by the basic principles on the use of lethal force in firearms, where firearms should only be used as a measure of last resort. Therefore, Your Excellencies, because of the fact of this disproportionate use of force by UP police, this had resulted in the applicant's violation of their right to humane treatment because of the suffering effects of the PTSD that they had suffered, Your Excellencies. And Your Excellencies, if this court takes cognizance of the fact that we are indeed in a digital era of human rights, it only pushes them.
Counsel, may I just, maybe I misheard some, because the internet connection is a little bit problematic in some aspects, so I turn off my video sometimes too. But I want to ask you, do you want to say that there is an additional positive obligation, like a new standard to be applied in terms of positive obligation of a respondent state to protect the human rights in concreto in this situation due to usage of artificial intelligence and also in general in digital age?
Yes, Your Excellency. And as we can see from the jurisprudence of the Inter-American Court, in the case of Baldeón Garcia, the court has already taken a step in this direction by determining the fact that next of kin can still suffer a violation of their right to humane treatment, even when they're not physically present in the events that occurred. It is the effect on their mental integrity, which is what we urge this court to see here and to take that step just one step further, Your Excellencies, and acknowledge the use of these advanced technologies. Your Excellencies, the world is on the move, but from the United States to Nigeria, to the Republic of UP, protests and assemblies remain one of the most articulate forms of people's political expression. Today, we are urging this court to send a message to states that the protections enjoyed by those who peacefully assemble extends to their mental integrity. Without your intervention, these victims...
Excuse me, Counsel, would you also argue that robots have human rights?
No, Your Excellency, that is not our argument at all. Our argument is, Your Excellency, the fact that the humans who were controlling these robots are the ones who are affected.
And what in this particular case, where there was a clear provocation of the security forces, what would have been, in your opinion, a less intrusive, a less excessive use of force that would have been proportionate?
Thank you, Your Excellency. And as noted in the Special Rapporteur's report of Mina Kiai and Christoph Heyns in 2016, several less lethal options exist to disperse an assembly, such as the use of water.
You will have a chance to fully answer the question of Judge Nowak now, even though your time is up. But please proceed with the reply.
Thank you, Your Excellency. And as noted that my time is up, may I kindly request for 1 minute to conclude on my submissions as well as...
you have more than 1 minute, but you must reply to Judge Nowak, please.
Thank you, Your Excellency. Justice Nowak, as I was submitting, in the Special Rapporteur's report of Mina Kiai and Christoph Heyns, it was recognized that several less lethal options exist to disperse an assembly, such as the use of water cannons, the use of tear gas, the use of police charges. Your Excellencies, these less lethal options were not used at all, and the police resorted to the use of force, which was by no means the minimum extent necessary. Therefore, this was disproportionate and therefore unlawful.
Counsel, may I ask you in this case whether you agree that what we're dealing with here is destruction of property? So as far as the police is concerned, they thought people involved, but they destroyed property, they destroyed robots. Of course, if one can argue that fish have rights, maybe one can argue that robots have rights, but that's not your argument in this case. But you mentioned that firearms are a measure of last resort. What would you say to the argument? Yes, that applies when you are dealing with attacks on human beings, but this is destruction of property. And so you mentioned the report of the two rapporteurs, which say that tear gas and so forth should be used. But can tear gas be used in this particular case to stop the robots? Is that a realistic option? And in the end, what happened here is merely that property was destroyed. People who knew this was only property, it was not human beings, now said that they were traumatized. But should this court really believe that they were traumatized because they knew this was merely property that was being destroyed?
Your Excellency, that is exactly where the standard that we are drawing exists and comes into play in this instance. First of all, the police officers thought that the applicants were humans, that the holograms were actually humans. And therefore, their honest and reasonable belief, while it is important, it must be assessed taking into consideration the fact that police officers undergo specialized training to respond to these circumstances. It is not the same assessment that would be conducted on the decisions of an ordinary person. And in the present matter, to justify such disproportionate use of force, there has to be an imminent threat. No such imminent threat existed, Your Excellencies, as the record shows no indication of the governor nor the people in his household being threatened by the protesters in any way. And furthermore, the protesters were moving slowly towards the governor's residence and only appeared to be carrying spears. This was also a peaceful protest, Your Excellency. The respondent state cannot in any way insinuate that there was violence that could actually give rise to an immediate threat to the lives of others. Therefore, the use of force by UP police contravened Basic Principle 13, which restricts the use of such force to the minimum extent necessary. If that satisfies your questions, Your Excellencies, we submit that in addition to the applicant's right to humane treatment being violated, the UP police violated the principles on the use of lethal force, thereby rendering it unlawful.
Thank you very much, Counsel. We will now proceed to the respondent. But since we allowed an extension of time to the applicants, this is just to give notice to the respondents that there would be similar flexibility for their time allocation.
Thank you very much, Your Excellencies.
Thank you, Counsel. Can we proceed to the first counsel from the in behalf of the respondent?
Thank you, Your Excellency. President of the Court, Your Excellencies, may it please this Honorable Court, receive greetings from the Silicon Valley of UP as you continue to live UP in community. Before you are counsels appearing on behalf of the Federal Republic of United Perigma. Appearing as the first counsel for the respondent, my name is Martin Kioko Munyoto. Appearing alongside me as the second counsel for the respondent is Sydney Tambasi Netia. Of the 30 minutes allocated to us so graciously by this court, I will use the first 15 minutes to submit on the contentious preliminary issues, then proceed to guide this court on the merits of issue B regarding the federal law on blindness and issue C regarding the federal law on education. I will then pass the baton to the second counsel who will use the subsequent 15 minutes to address this court on the merits of issue A on the federal law on pesticides and in issue D with respect to the prosecution and the use of force under the Assembly Public Order and Security Act. In the absence of any inquiries from the bench, I will begin. Regarding jurisdiction, the respondent acknowledges that this court has met the requirements of jurisdiction since UP's withdrawal from the Sierra Helada Continental Union on the 15th of March 2020 does not affect the jurisdiction of this court. Regarding the admissibility of claims, the rules of admissibility applicable in this case correspond to those highlighted under Article 46 of the Sierra Helada Human Rights Convention, the requirements being inter alia that domestic remedies have been exhausted. Your Excellencies, the obligation to exhaust domestic remedies is fundamental rule and is based on the rationale that states must be accorded an ample opportunity to redress any allegations of human rights violations within their local systems before the obligations and international law are invoked. This, Your Excellencies, was propounded in the leading authority on this criteria by the African Commission in 2000 by the case of Sajawara versus the Gambia. The Commission at paragraph 32 held that a remedy is considered to be available if the petitioner can pursue it without impediment, is deemed to be effective, if it offers a prospect of success, and is sufficient if it is capable of redressing the complaint. In the present case, Your Excellencies, the respondent asserts that issue A and issue D are not admissible because remedies were not exhausted. Regarding the federal law on pesticides, by dint of paragraph 20 of the facts of the case, after the law's enactment in April of 2020, there has been absolutely no attempt by any party to challenge this law in any courts within United Pragma. Therefore, the fact that there has been absolutely no attempt to exhaust these domestic remedies that were available means that the state was denied an opportunity to redress this complaint. We rely on the case of Bakuri Land Claims Committee versus Cameroon, decided by the African Commission in 2014, where the court held that in order for an applicant to trigger the exception to the requirements of exhaustion of domestic remedies, they must at least attempt to exhaust these remedies. Therefore, the exceptions under that rule do not apply to the applicant since they made absolutely no attempt to exhaust those remedies. Regarding the Assembly Public Order and Security Act, pursuant to paragraph 31 of the facts of the case, at the time of the filing of this application, this matter had also not been argued before any court in United Pragma. In this case as well, there was no attempt to exhaust domestic remedies. It would therefore be unjust for this honorable court to admit a claim that has not been interrogated by the respondent, because this would be in stark contravention of the principle in the exhaustion of domestic remedies that requires that the states are not just accorded an opportunity, but an ample opportunity to redress these complaints. The present state, Your Excellencies, has shown a commitment to redress remedies. This can be seen in the fact that, pursuant to paragraph 2 of the facts of the case, the state has a robust judicial system, allows people with requisite standing to appear before the court. As a matter of fact, by dint of paragraph 11 of the facts of the case, the reversal of a decision in favor of the state by the Supreme Court in IP shows that this judiciary is independent. Regarding the claim by the applicant...
Excuse me, counsel. So thus far, I just want to keep track of your argument. Thus far, you are saying that there was no exhaustion for claim D?
Indeed, Your Excellency.
Even no attempt to exhaust, and for which is the other claim?
Claim A, Your Excellency.
So A and D, you're saying there was no exhaustion. Fine. What's your position on claims B and C with regard to exhaustion, counsel?
Thank you for the question, Your Excellency. In regard to claim B, the federal law on blindness, the respondent acknowledges that domestic remedies were exhausted in this matter. This is by dint of the fact that the matter was argued up to the Constitutional Court. In the case of claim C, which is the federal law on education, the respondent concedes that in that case, remedies are not available because the Constitutional Court, which has exclusive jurisdiction on human rights matters, held that it had no jurisdiction. Therefore, the respondent acknowledges that claims B and C are admissible, but requests this court not to admit claim A and D because remedies were not exhausted.
Regarding, may I, sorry to interrupt, but on claim A, the pesticides, didn't the Constitutional Court already rule that Rosabest Incorporated had no legal standing? So what else should they have done in order to exhaust domestic remedies?
Yeah, and just to connect, to connect to this, how can you prove actually effectiveness of a remedy in this concrete case? You mentioned prospect of success, but then when you elaborate, you just divide claims without actually emphasizing effectiveness that you could prove of this or not.
Thank you. I will begin with His Excellency Justice Nowak's question, which regards the claim regarding the federal law on pesticides and the fact that Roosevelt Inc. was held to have no standing. Your Excellencies, I will rely on the case of Velasquez Rodriguez versus Honduras before the Inter-American Court of Human Rights in 1988, where the court held that it is not for the international courts to decide on the procedures of the national courts. In this case, Your Excellencies, this honorable court cannot decide on whether it was merited for the national court to hold that the applicant in that case had no standing. Pursuant to paragraph 13 of the facts of the case, it is seen that Salvador, the firebrand environmentalist, was granted standing before this court. This therefore means that any party which meets the requisite standing before that court can be allowed an opportunity, and therefore the remedy was indeed available. In the case of effectiveness, replying to Justice Jelić's question, I will rely on the case of Kenya Human Rights Commission versus Kenya, decided in 1995 before the African Commission on Human and People's Rights. In this case, the applicant sought to register an ungovernmental organization in Kenya and relied on the fact that the president of Kenya had made statements to the effect that that organization would not be registered. Now, banking on that, the petitioner failed to exhaust domestic remedies in Kenya and went directly to the African Commission, stating that the remedies in Kenya were not available. Your Excellencies, this is analogous to the current situation where the applicant relies on the unverified statements by the Chief Justice. It is the respondent's averment that personal statements made outside court do not affect the effectiveness of the remedy because they cannot be considered as a rationale for holding that remedies are not available. This also was held by the Human Rights Committee in the case of RL versus Canada, decided in 1991, where the committee held that the author must at least attempt to exhaust domestic remedies, and the effectiveness of these remedies can only be interrogated upon them attempting to exhaust these remedies. If Your Excellencies are satisfied with my arguments on preliminary issues, I will proceed to the merits of the case. As
Counsel, you aptly mentioned some precedents in connection with exhaustion of remedies. But haven't these courts and treaty bodies also made reference to the context in which we're expecting the petitioners to exhaust the remedies, not merely the existence of the remedy, or that in theory they're not impeded from exercising them, but that actually the context, also has to be taken into account in order to evaluate whether those remedies are adequate, actually accessible, and they have a chance of success.
Thank you for your question, Your Excellency. I will respond to it in two respects. One, I will establish that indeed this interpretation on the exhaustion of domestic remedies must be done on the basis of context. In this case, Your Excellency, pursuant to paragraph 11 of the facts of the case, it is seen that a decision has actually been entered against the state. This means that there is a prospect of success and the judicial system in United Pragma is indeed independent. Secondly, per paragraph 2 of the facts of the case, the judicial system in United Pragma and in the Isle of Penguins and the other federal states is robust in the sense that it provides for many avenues. Pursuant to paragraph 13 of the facts of case and also paragraph 25 of facts also, there has been two judgments, one the Hague judgment and another judgment by the FLB. This means that the judicial system is able to give remedies to any complainants that come with merit before it. I will rely also, Your Excellencies, on the case of Nowak Justice Council versus Ethiopia before the African Commission, where the Commission held that casting doubts about the effectiveness of a remedy should not be admitted if, in the view of the Commission, it is incumbent that the complainant has not taken all the necessary steps to exhaust or at least to attempt to exhaust. Therefore, what the applicant does in this case is to only cast aspersions without attempting to exhaust the remedies that are available. I will proceed to the merits of the case, where I'll be handling issue B, which is whether UP's federal law on blindness violates Catalia Rosario and her family's human rights. The applicant has alleged that the FLB violates the rights of the child to be heard and the principle of the best interest of the child, since it is of a coercive nature. However, at the heart of the respondent's argument in this case are three central assertions. One, that the federal law on blindness was enacted in furtherance of the state's international obligations as set out under Article 25, of the Convention on the Rights of Persons with Disabilities, as well as Article 15 of the International Covenant on Economic, Social, and Cultural Rights. Secondly, that the federal law on blindness is founded on the principle of the best interest of the child as enumerated in Article 3 of the Convention on the Rights of the Child, and in any case, that this law qualifies as a lawful limitation of the right to privacy of the mother. I will begin with my first argument, which is as FLB was enacted in furtherance of the state's obligations. By dint of Article 25 of the Convention on the Rights of Persons with Disabilities, specifically in regard to health, it obliges state parties in ensuring that persons with disabilities attain the highest attainable standard of health to put in early identification and intervention as is appropriate, more specifically in the case of children. An objective reading of paragraph 22 of the facts of the case, therefore, reveals that the federal law on blindness seeks to carry out early identification and intervention in the case of these visually impaired children and those with high chances of becoming blind. Therefore, in enacting
may I interrupt, counsel? But isn't that precisely the point of the applicants, that such a definition of what is in the best interests of the child, of what is in the best interest of a person with disability, is in fact what they are contesting. And that, as attested to by the daughter, that perhaps the conventional view of blindness as a disability has to be adjusted. Can you just address that point? How to define what is the best interests of the child? How to define what it means to respect the rights of a person with disability?
Thank you for the question, Your Excellency. Your question actually guides me to the second limb of my argument, which is that the federal law on blindness is founded on the principle of the best interest of the child. In this case, Your Excellency, the response relies on General Comment number 14 of 2013 by the Committee on the Rights of the Child, specifically under paragraph 4, where the committee states that the concept of the child's best interest is aimed at ensuring the child's both full and effective enjoyment of all the rights and to ensure the child's holistic development in society. This, Your Excellencies, is a dynamic concept that must be assessed appropriate to the specific context. In this context, Your Excellencies, the respondent acknowledges that the assessment of the best interest of the child is neither for the state nor for the parent to determine exclusively. For instance, in this case, in the view of Catalia and her family, being grounded in religion is in the child's best interest. However, in the present case as well, the state seeks to invite this court to agree that the best interest of the child is in ensuring their full and effective enjoyment of the rights. This will be advanced by curing their blindness by dint of the federal law on blindness.
But sorry to interrupt here. Are you not here applying the outdated model, the medical model, in relation to rights of persons with disabilities, so that you can cure a disability? I think the Convention on the Rights of the Child is clearly applying a human rights model of inclusion, non-discrimination of persons with disabilities, rather than thinking it's a disease that needs to be cured.
Thank you for the question, Your Excellency. In regard to inclusivity and non-discrimination, the General Comment acknowledges that the conflict on the best interest of the child might arise. Pursuant to paragraph 81 of that General Comment, it provides that the committee acknowledges that various conflicts might arise in determining the child's best interest. However, at paragraph 82...
Excuse me, your time is up, but considering that there are questions from the other judges, and if other judges would like to ask their own questions, we will proceed with the oral argument of Mr. Muñoz. Please proceed, counsel.
May I just ask counsel to also address the connection between a right to participation of a child with the best interest of a child, and could measures be imposed necessarily without consultation, without participation, because this is also one of the most important principles concerning right of a child protection.
So, counsel, please proceed to reply to both the questions of Judge Nowak and the question of Judge Jelić, please.
Thank you. I will begin by His Excellency Justice Nowak's question, which is that in assessing the best interest of a child, the overarching principle as established under paragraph 82 of the general comment is in ensuring that this ensures the full and effective of enjoyment of the rights under this convention. By dint of paragraph 8 of the facts of the case, it is seen that Monteiro Rosario, who is the father of Catalia and the unborn baby, had to resign from his earlier profession as a scientist because he turned blind. This means that his blindness did not allow him to fully enjoy his right to work. In this case, Your Excellencies, if Your Excellencies agree that the deprivation of the child's liberty is a deprivation of the childhood, then the deprivation of a child of the right to fully and effectively participate in society is not only a deprivation of their childhood, but of their future as well. Allowing these children to be cured of their blindness will ensure that they grow fully and effectively in society, enjoying all their rights that accrue to them as children and in the future. I will request the Excellencies to allow me 1 minute to reply to the issues regarding the federal law on education.
Yes, in fact, you have more than 1 minute. Let me see. You have 3 minutes just to equalize the time allocated with the other party.
Thank you for the grace, Your Excellency. I will proceed to argue on whether federal law on education violates the rights of Catalia and other penguinatics. The applicant in this case has alleged that the federal law on education violates Catalia and other penguinatics' right to manifest their religion and belief in worship. This right, the respondent affirms, is not absolute and is subject to a 3-part test as set out under Article 18.3 of the International Covenant on Civil and Political Rights. This test, as established in the case of Eweda and others versus United Kingdom before Strasbourg, is that it must be prescribed in law in furtherance of any of the legitimate aims and that it must be necessary. In contention before this court, as advanced by the applicant, is the necessity of this law. Necessity, Your Excellencies, in this context requires the balancing of rights between these competing rights, which must be proportionate and justified in principle. First, the principle which is used to limit this right is a legitimate aim. By dint of paragraph 24 of the facts of the case, the respondent uses the legitimate aim of public safety to limit the right to manifest one's religion. This is seen in the fact that the federal law on education was enacted after protests erupted in public schools, and this was fueled by the fact that there were videos demeaning persons with disabilities and making outrageous claims. In an attempt to protect these persons with disability and in an attempt to ensure that there is the safety and security of learners in public schools, the federal law on education was enacted. This law is proportionate in the sense that it only applies to public schools. By dint of paragraph 26 of the facts of the case, it is seen that this law only limits the use of the Dale Galapagos in the context of schools. Therefore, the law is not unproportionate because it doesn't apply to the whole country. It doesn't ban the use of the Galapagos in the markets, doesn't prohibit the use of Galapagos in the cities. It only prohibits the use of Vale Galapagos in the context of the schools because this violence happened in school. In relation to the least restrictive measure, as raised by the applicant, the respondent asserts that this was the least restrictive measure because the violence in the public schools made it difficult for the police to conduct investigations, and therefore this hampered the right, the work that they do, and this was in contravention of the state's obligation to ensure the safety and security of learners in public schools. Seeing that my time is far much spent, I will now pass the baton to the second counsel for the respondent, who will advance our arguments on issue A and issue D. Thank you for your time, Your Excellencies.
Thank you. Thank you, counsel. We will now hear from the second counsel for the respondent.
Greetings, Your Excellencies. Picking up the baton from my co-counsel, Mr. Kioko. My name is Sydney Tambasi Netia, second counsel for the respondent. Of the 15 minutes remaining, I will be addressing this court in response to claims A on the federal law on pesticides, as well as claims D on the use of force on the 3rd of May 2020. On to the first claim, the applicants have alleged that the state has failed to meet its minimum core obligations with respect to the right to food. However, Your Excellencies, it is our submission that FLP was enacted to prevent the severe environmental degradation, and in doing so, to meet its duty to protect the right to adequate food of IP citizens. In substantiating my position, Your Excellency, I shall first map the general contours of the right to food. Secondly, address the most contentious issue, which is the situation of malnutrition and starvation. And lastly, conclude by justifying the state's radical decision to ban the toxic pesticides. Your Excellencies, the general framework of this right is provided for in Article 26 of the THHR Convention. This is read together with Article 34J of the Charter of Organization of American States. And this mandates state parties to ensure the availability of food as well as proper nutrition. The right is also reflected in Article 11 of the International Covenant on Economic, Social, and Cultural Rights. Your Excellencies, in interpreting this right, the Committee on Economic, Social, and Cultural Rights, in its general comment number 12, under paragraph 7, 8, and 10, as read together with the 2017 report of the Special Rapporteur on the Right to Food under paragraph 5, that is Professor Hilal Elva, specifies that this protective mandate is not only to ensure that the food is of a sufficient quantity, but also to ensure that food is safe, it is qualitatively adequate, and free from adverse substances, specifically toxic pesticides. In this case, Your Excellency, Rosapel's 2018 cheaper toxic pesticides. The African Commission, in its guidelines on implementation of socioeconomic rights, also recognizes under paragraph 86 that part of this minimum core obligation is to ensure that food sources are not contaminated by adverse substances. Your Excellency, if the state would have allowed the Rosapelt Inc. to continue producing, distributing, and disseminating these toxic 2018 pesticides, then the state would be in violation of its obligation to protect a clean and healthy environment and safe food. Your Excellency, these two rights, as stated in the case of La Cajonia versus Argentina 2020 before the Inter-American Court under paragraph 208, as well as 221, are interconnected, are interrelated, are inseparable, and are compounded. Therefore,
excuse me. Well, it's quite clear that the pesticides were toxic for the animals. But is there any allegation it was actually toxic for human beings?
Thank you, Your Excellency. In response to your question, I will rely again on the 2017 report on the Special Rapporteur on the Right to Food, Professor Hilal Elva. She specifies that sometimes the effect of the use of toxic pesticides on human lives is not felt in months, sometimes it's not even felt in years. It is true that in this case, there has been no report, but then the state was called to exercise a very complex mandate here, that there was toxic pesticides being used by people who are majorly reliant on agriculture, and therefore, if the state would have allowed these toxic pesticides to continue being used, then at a later date, not now, Your Excellency, the state might have been unable to rectify the effects of these toxic pesticides, which range sometimes to very severe health conditions like cancer, Your Excellency. Your Excellency, the applicants submitted that the state had not conducted its due diligence in respect to establishing the causal link between the toxic pesticides and the chemicals causing the environmental degradation. In response to that, Your Excellency, the respondents submit that pursuant to the precautionary principle, the lack of conclusive scientific evidence in and of itself cannot be used as an excuse by the state not to take an action in cases where there are chances, or in this case, there are actually severe environmental degradation and harm. Therefore, Your Excellency, allow me to address the most contentious issue, which is the malnutrition and starvation. And Your Excellency, quite admittedly, the situation in the island is very bad. Your Excellency, the invitation of the respondent is that the state should not look at this as an unwillingness on the part of the state to respond. And Your Excellency, I will advance this in 3 stages. That first, let us put it into perspective. Pursuant to paragraph 4, paragraph 7, and paragraph 20 of the fact pattern, the government at the time when it was enacting this federal law on pesticide was fully aware that these same citizens of IP had practiced sustainable agricultural practices, produced their food for over 50 years since the creation of the modern state of IP in 1970. That was what the state knew. Secondly, Your Excellency, the time within which these reports came into light and to the knowledge of the state, and the time within which the state is being called into action is a very short limited of time. When we look at paragraph 14 of the fact pattern as read together with paragraph 32 of the fact pattern, the reports came in March and the state has been dragged to court in the blink of an eye only 30 days later, Your Excellency. Relying on the Inter-American decision of the case of Sahoyak Sahama versus Paraguay, 2006, under paragraph 247, in a very similar circumstance, where the Inter-American court found that the state of Paraguay had violated the right to food of this Sahoyak Sahama community by allowing them to continue being malnutrition for a period of over a year. The court gave Paraguay 6 months to rectify the situation and then report back to the court. Therefore, in this case, that very severe situation of malnutrition and starvation could not have possibly been rectified in 30 days alone. Lastly, Your Excellency, I will finally rely on the special rapporteur, the report of Professor Hilal.
Counsel, you mentioned the Sahoyak case, but rather than the time period, the consideration of the court was that the situation of lack of care and lack of access to food was so severe for indigenous children in that particular community that the state had a responsibility towards the right to life, physical integrity, and health. So, can you rephrase your argument, because it doesn't really, it's not really connected to how long, how many days does it take for the state to discharge their responsibility. But could you comment on the responsibility of the state vis-a-vis the right to food and the right to care and to health of a population that is in a vulnerable situation?
Thank you, Your Excellency. In response to your question, I will rely on the same Sahoyak Sahama case, where it is true that in that case, the situation had raised the question of the right to life. Also, one of the contentious issues in that case, Your Excellency, was the situation of malnutrition and starvation, which is the specific part of the judgment, the specific context of the judgment that I have relied on. When the state was found in violation of the right to food by allowing the continued malnutrition and starvation of the people, the court allowed the state a period of 6 months to report back. With respect, Your Excellency, to the right to health, the special rapporteur, Professor Hilal Elva, in a 2017 report specifies that the use of toxic pesticides in a human population is fundamentally incompatible with not only the right to food, but also the right to health. And sometimes, Your Excellency, in fact, Your Excellency, she says that in paragraph 40, in most cases, these repercussions are sometimes permanent and irreparable. Therefore, Your Excellency, even the narrowest interpretation of General Comment number 12, as read together with Article 11 of the ICESCR, cannot lead to a conclusion that food which is contaminated by toxic pesticides is qualitatively adequate, nor is it sustainable. Your Excellency, allow me then to address the last issue on the issue D on the prosecution and use of force under APOSA. Mr. President, Your Excellencies, the applicants have alleged that the respondent has violated its right to a humane treatment of Catalia and her friends. However, Your Excellency, the submission of the respondent is that the respondent has not violated the right to a humane treatment, but that has fulfilled its obligations that accrue from the use of force in the context of an assembly. Your Excellency, the applicant has also said that the holograms in and of themselves constitute the assembly. However, the respondent is of a contrary opinion that the holograms in and of themselves cannot constitute the assembly without the human element, that is the involvement of Catalia and her friends. And Your Excellency,
couldn't your state have taken less extreme measures against the holograms? Because you are known for your expertise in high technology, in artificial intelligence, and yet perhaps you could have just taken some sophisticated technology to take down the holograms. Maybe you could have, I don't know, zapped the signals being sent to the robots, but instead you used live ammunition to smash the things. So in terms of proportionality, can you address the argument of proportionality which was made by the applicant, please?
Thank you, Your Excellency. In addressing the proportionality, this is always addressed when two fundamental factors are in play. Your Excellency, the fact that there is a state which has violated its obligation, and the state being the duty bearer. On the other hand, Your Excellency, there must be a recipient, individuals, actual human beings, like you and myself, Your Excellency, with blood, flesh, and bone, Your Excellency, who are then the right holders in traditional international human rights law. Your Excellency, in this case, our submission is not as to the proportionality or to the disproportionality of the use of force on that day, Your Excellency. Our submission is that whenever force is used in the context of an assembly, certain obligations accrue. And in this case, the state has met its obligations. When we read the African Commission Guidelines on Policing Assemblies under its operative paragraph 21.2.2.3, as read together with the United Nations Human Rights Guidelines on Less Lethal Weapons under its operative paragraph 23.4, then the moment human beings, actual right holders, are affected by use of force, then the state must allow them to receive immediate medical assistance, and the state must not interfere with this medical assistance. When you look at paragraph 29 read together with paragraph 30, when Catalia and her friends suffered post-traumatic stress disorder, Your Excellency, the state allowed them to receive medication from the MDC facilities.
Excuse me. Excuse me. Sorry, Manfred? Yeah.
No, please go ahead. I come up.
Just short, please, Council, could you and how justify that the measures undertaken actually were the last resort measures in this case? That I think would be useful to know.
And perhaps if I may add, the right to assembly is defined as the right to peaceful assembly. Would you argue that the use of robots in an assembly is actually not even covered by the human right to peaceful assembly?
Thank you, Your Excellency. I will begin with answering Justice Jelić's question on the least restrictive measure. In this case, Your Excellency, the least restrictive measure normally under the international human rights standards is judged according in the context of a peaceful assembly. And there are three fundamental components that have to be taken into play. This is decided by the case of Landaeta, Mejias Brothers versus Venezuela, 2014 before the Inter-American Court under paragraph 134, where the police officers have to assess the level of threat. The police officers have to look at the attitude of the individual and we have to take into the consideration the available equipment. When you look at paragraph 29, Your Excellencies, these police officers began by instituting a negotiation. They actually told Catalia and her friends who are behind the robots that they would be left with no other choice but to shoot into the crowd, Your Excellencies. And quite admittedly, as a state, we are happy that in this case, there are no recipients of the use of lethal force by the police officers. However, Your Excellencies, as to the proportionality, we do understand by Mr. Kiyoko's, the first applicant for the respondent's submissions, that then the state has an obligation to take an investigative mandate and look into the use of force of these law enforcement officials as against human beings, and then charge them in the courts and provide reparation for the injured victims, as well as hold the officers into account. In response to Justice Nowak's question, I will rely on General Comment number 37 of the Human Rights Committee, which is the latest interpretation of the right to freedom of assembly. And in this general comment, quite admittedly, Your Excellency, the Human Rights Committee does not make a case for hologram assemblies. It does not recognize a hologram assemblies. And Your Excellencies, when we went through the state reports, none of the 23 delegations, including Spain itself, which had the hologram demonstration in 2015, made a submission and made a case for hologram assemblies. However, Your Excellencies, when we dug deeper, we got to paragraph 13 of this general comment, and the Human Rights Committee does recognize the remote participation and organization for an assembly and gives the example of an online assembly, Your Excellency. Therefore, in this case, Your Excellency, despite the fact that the holograms in and of themselves do not qualify as an assembly, but then the fact that they are being controlled remotely by Catalia and her friends, then the right to peaceful assembly has been qualified in this case. Lastly, Your Excellency, it is fundamental that in the case of use of an assembly, and in the case of a very new concept in this case, that then there must be a recourse to cause after force has been used in this context. And this is also recognized in paragraph 69 of the general comment. Therefore, the submission of the respondent is to enable the domestic decision-making to take place, as it is the first line of defense in such instances, Your Excellency. In conclusion, we do pray, Your Excellency, that—
Counsel, I want to ask you on the issue of the definition of a peaceful assembly. So you did refer to General Comment 37, and of course the rapporteur on assemblies and association has written a lot about that. And the question there was whether a digital assembly or online assembly or a remote assembly, whether that can qualify as a peaceful assembly for the purposes of Article 21. So as you rightly say, in paragraph 13 of the General Comment 37, the General Comment talks about remote assemblies, for example, online assemblies. And doesn't that mean that in principle, digital assemblies like a hologram would be included? It's only one example to say online, but in other ways, one can also assemble online. So the scope of the right seems to be that that such assemblies and holograms, as you mentioned, Spain and so forth, would be included. So my first question is on the scope. And then the second one is on the use of firearms. Would you agree with the applicant in referring to the basic principles that there are very strict conditions on which firearms may be used? Generally, they may not be used at all, except if there is a grave or an imminent threat to life or a grave threat of serious injury. And in this case, all we had was holograms going through iron gates. So clearly it was not human beings, it was just holograms going through. So was it at all acceptable to use firearms in this particular context?
Thank you. Counsel, your time is up, but you will have 3 minutes to answer fully the last question propounded to you. And then we will proceed to the rebuttal. Please.
Thank you, Mr. President, and also Professor Haynes. In response to the first question as to the scope of the right to freedom of assembly, Your Excellency, it is the understanding of the respondent that then the right is owed to the right holder being human beings. And in this case, Your Excellency, the moment actual human beings, Catalia and her friends, suffered from as a result of the use of force by the law enforcement officials, then the state stepped in to allow for their medication, and despite issuing a charge for their arrest, did not effect this charge, but allowed them to receive medical treatment before then the actions are put to scrutiny before the judicial system. Lastly, Your Excellency, with respect to the last question, the position of the respondent is that given that this is a very new concept, given that the Human Rights Committee has not even recognized the concept of a hologram assembly, and also given that this is only the second time in the world, Your Excellency, that a hologram is being used in the context of an assembly, it is only our plea, Your Excellency, that we allow the domestic system, we allow UP to develop its own law in response to this context and in response to the development in technology. Your Excellency, and the justification for this is that this domestic judicial system is the first line of defense. Lastly, Your Excellency, redress in the context of use of force in an assembly is accorded to human beings. So if an argument were to be made that holograms enjoy or are right holders, Your Excellency, redress cannot be given to objects that do not even hold the right in the first place. And in this case, Catalia and her friends need to be allowed to access this redress through the domestic judicial system. Your Excellencies, I would like to end with a concluding note. When we signed the Unity Accord in 1970, creating the State of United Perigma, and further ratifying the international instruments in question here today, we entered a solemn undertaking to guarantee the rights of our people. And to this effect, Your Excellency, we have respected, we have fulfilled, and we have protected these rights, Your Excellency. Where we have fallen short, we have been able to be quick to right our wrongs. And therefore, we pray that you may dismiss the applicant's submissions, and if not, Your Excellencies, that you find that the respondent is not in violation of its international or domestic human rights obligations. Thank you very much, Your Excellency, Mr. President.
Thank you, Counsel. Can we now proceed to the rebuttal argument by the applicants? Who will do the rebuttal?
I shall be doing the rebuttal, Your Excellency.
Please.
The applicants have the following points of rebuttal. On the admissibility of the FLP, we submit that the remedies were exhausted as the Constitutional Court addressed itself on the substance of the law, which, according to the European Court in Ahmed Sadiq versus Greece, amounts to raising the complaints in the same or like effect. Regarding the merits of the FLP itself, as the Inter-American Court noted in its 2017 advisory opinion to Colombia on the environment, the duty of due diligence is a precautionary measure to establish the risk and manage such risks on human beings. Therefore, time cannot possibly be an excuse for the violation of the minimum call on the right to food. On the FLE, the respondents failed to address the applicant's argument on the use of facial recognition technologies as a last restrictive measure. And lastly, Your Excellencies, on the use of force, states are obligated to use force to the minimum extent necessary and as a last resort, according to the basic principles on the use of force in firearms. The respondent state failed to do so. If that pleases Your Excellencies, that concludes the applicant's rebuttal.
Thank you so much, Counsel. That concludes the hearing for today.
Thank you very much. Thank you, judges. Thank you, participants. At this stage, we will take about 15 minutes for the judges to deliberate, and they will do this via a different Zoom link. While the deliberation is taking place, we will have a brief discussion on a peer-to-peer discussion, actually, with colleagues at the Office of the High Commissioner for Human Rights and Professor Christoph Heyns, particularly as it relates to the links between the World Moot case and the soft law instruments which participants have used. So with that, the discussion will be moderated by Dr. Michael Vina. Michael has been working with the OHCHR since 2006, and he has been a visiting fellow of Keller College at the University of Oxford since 2011. He has also been working on the design and implementation of the Rabat Plan of Action on incitement to hatred, and the Beirut Declaration on Faith for Rights. Michael has also judged the World Moot competition for a number of years. And the discussants, the persons who will be having this discussion, will be Professor Christoph Heyns. He has, as you know, he's just been a judge, and Mr. Ibrahim Salama, who works at the OHCHR in the Human Rights Treaties branch, where he leads the Faith for Rights program. Previously, he headed the UN Secretariat for the preparatory process of the 2009 United Nations World Conference Against Racism, which was termed the Durban Review Conference, and was an independent expert of the subcommission the promotion and protection of human rights, and was elected the chairperson of the Intergovernmental Working Group on the Rights to Development. So this will be a brief 15-minute discussion while the judges enter a different chat room to deliberate.
Thanks a lot, Eduardo.
I think Michael, are you?
Yes. Thanks a lot for this introduction. And actually, we wanted to use these 15 minutes while the judges are deliberating. So to use this cliffhanger moment to give an opportunity to have a peer-to-peer discussion on the practical links of the Mandela Moot Court case this year with these two distinguished speakers. But since it's peer-to-peer, it means that it's not just among the panelists, but I would really encourage all of you to send any questions that you may have, also from the two teams who have just presented their arguments, either through the chat box, or if you want to take the floor, I can also give you the floor over the Zoom link, so that we can make it really as an interactive discussion. I would like to start with the first question to Christoph, because obviously you have been the rapporteur for the Human Rights Committee's General Comment number 37. You also co-authored the Human Rights Council report on the proper management of assemblies, and you've just judged the final round of the Mandela Moot Court. What was your impression of how the students picked up the case law of the Human Rights Committee, notably the recent General Comment on the right of peaceful assembly, and also the joint Special Rapporteur's report in their oral pleadings? And I remember you had also a follow-up question to the respondent just 10 minutes ago. Over to you, Christoph.
Yes, thank you very much. And I must say, I really enjoyed the presentations by both teams. And it was indeed a special feature that they did refer to a lot of the soft law, if one wants to use that term, that has come out of the treaty system, but also from special procedures. Of course, it's not completely without coincidence, because some of us are involved in giving ideas, not only myself, but others who are on the screen, giving ideas on what should go into the problems that are presented for these moot competitions. But that's part of the process, that we want to make sure that there's more engagement with the system. So I was struck by the references to the reports from special procedures for example, on the right to food and on the environment, which is a difficult issue, and where we got very, I think, useful references. Is it just the existence of food, or is it the quality of food? And going back to what the rapporteurs have said about that. On the references to the on peaceful assembly, yes, I think it still remains useful to refer, for example, to the 2016 joint report of the rapporteurs on executions and on assembly. Of course, that has largely now been overtaken by the two new documents, General Comment 37, and also the guidance on less lethal weapons. So I would think, for a point that is covered by both, it's probably best to cite the more recent one. In this particular case, the reference was to the 2016 report that less lethal weapons must be used, but there's a whole guidance on that now. But from various of the council that appeared, and of course they've gone through a number of iterations of this competition, so by the time they reached the final, I think they're really up to speed, and we saw that with the way in which they engaged. I was impressed by how they engaged with paragraph by paragraph and the actual language to engage with saying, well, this has been picked up in the less lethal guidance that the office has issued, and in the general comment, in particular this issue of online assemblies, which is, I think, which is a burning issue. And it's not only online assemblies. The office recently looked at the issue of facial recognition and so forth in the context of the right of political participation. And almost in anything that we work with today, technology plays a big role. Even less lethal weapons is a form of technology. And then we have mass surveillance and those sort of things. So I think it is inevitable, and it's really commendable also that these documents are looked at. So for a treaty like the Covenant in 1966, it has no reference to these sort of things. And yes, it has underlying principles, but treaties themselves are not really such flexible instruments. And I think the fact that we have Moore's law and that technology every 18 months double means that you cannot rely simply on treaties, because treaties can simply not keep up with the pace at which, and they're not designed to do that. So that's where soft law comes in. And I personally think this distinction between hard law and soft law is often overrated because we have so-called hard law instruments that play very little role. And then we have soft law instruments that really are the only ones, the only show in town. So I was delighted to see that the students do that. One of the questions that came in the last, actually last part of this final round was then the basic principles themselves. To what extent do the basic principles of 1990, do they still apply to the use of force in the context, in a digital context? So destruction of property of the robots, yes, but if it's a hologram itself, what are the limits on the use of force? Because a hologram is not really physical and untouchable. So do the basic principles still apply, and the rules on the use of firearms in particular in such a context? So I thought it was very interesting, and I was greatly encouraged by the way in which the effort that goes into drafting these interpretative documents that is picked up by the younger people, and that this is brought into the debate.
Many thanks indeed, Christoph, for also this juxtaposition of the hard law and soft law instruments. And perhaps turning over to Ibrahim now, since the Moot Court case alludes to various international soft law instruments. I mean, not only general comments, as Christoph was mentioning, but also the Rabat Plan of Action on the Prohibition of Incitement to Hatred, and also the Faith for Rights Framework. And also from your background as chief of the OHCHR's Human Rights Treaties branch, could you perhaps explain how these soft law instruments came into existence and how they are also used in practice, notably the Faith for Rights Toolkit?
Necessity is the best guide, is the best advisor in reality. And as Christoph just indicated, treaty bodies and special rapporteurs are doing a very fundamental task of not only contributing to the progressive development of the law. I love the quote of Christoph just right now. Treaties cannot keep up, and they're not designed to. In fact, yes, the many details and developments are fascinating, and I find the Moot Court that I read with attention, and I watched part of it, an excellent laboratory of the real life situations. It can even, it gives the creativity, the freedom to design the real life situations. And this, to me, comforted my conviction that what I call the extracurricular role of the mechanisms is very important. And while they do it separately in the thematic reports of the rapporteurs and in the general comments of the treaties, they can also, and this here comes the advanced mode of the extracurricular function of the mechanisms, they can do it together. I take the example of the Rabat Plan of Action because it was a perfect example. You might remember, Michael, we used to use the term at that time, the trio of relevant rapporteurs. It was discrimination, freedom of expression, and freedom of religion. So by definition, their mandates overlap on the issue of the speech. When should it be prohibited? When is it a correct expression of freedom of expression? And these guidelines were not clear in the treaties. And there is a fundamental political reasons why treaties cannot be clearer on this. It's because you cannot expect what will happen, and because some of the issues need expertise and need to go beyond the general political agreement while respecting the political agreement that states would have ratified. So here, I would add that in addition to the progressive development, the unspoken missing function is the constant reconciliation when rights are in tensions in particular situations. So Rabat is a perfect example of a constant reconciliation between Articles 19 and 20. 19 is freedom of expression, 20 is the prohibition of incitement to hatred. And I find that the Rabat Plan of Action, in my view, it's a mega general comment. It's a general comment on Article 19 and a half, as I joke about it, because it's really the threshold of what goes beyond freedom of expression and falls into incitement to hatred is somewhere between these two articles. Here you cannot expect legislators. It's not even the function. I like what Christoph said. They're not even designed to. because a legislator cannot go into this level of previewing what will happen. It has to be left to the interpretation. So the soft law is the, particularly in the form of documents like Rabat and Beirut, is an advanced mode of the individual interpretative role of the mechanisms when they do it jointly.
Many thanks. And just to add that obviously in the elaboration of the Rabat Plan of Action, it was not only the trio of special rapporteurs, but also the Human Rights Committee and the Committee on the Elimination of Racial Discrimination always participating. And also it's interesting to see that Human Rights Committee General Comment 34 is quoted in the Rabat Plan of Action. And then the subsequent third General Recommendation 35 on racist hate speech refers back to the Rabat threshold test. So I think it's a good example of where these soft law standards are actually being used by the treaty bodies, but also by other actors. Coming back to an interesting point that Christoph mentioned earlier on, also in the terms of the holograms, and which is obviously also alluded to in the General Comment 37, there's also a reference in the hypothetical case to the hashtag Faith for Rights. And I was wondering also if some of the students may have picked up and got interested in trying to find out more. It is there in the hypothetical case when protesters in the holograms dressed in Galapagos held placards with this hashtag. And then just going to this Faith for Rights toolkit, it includes very much a storytelling exercise about an award-winning short documentary about your father, Professor Johann Heyns. And I will just also put the hyperlink to that one. Could you tell us a bit more about this documentary and also the role of your father as the quotation marks exorcist of apartheid?
Yes. So the film you refer to is a short documentary that my son made about his grandfather, in other words, my father. And this is based on there's a story about the story. So the story is that my son spoke to my mother and asked her, what did my grandfather do during the time of apartheid? He was a prominent figure in the church. He was the head of the Afrikaans church in South Africa. And so he asked her, he obviously comes after the time, and he asked, what did my grandfather do during apartheid? And so she gave him a box with family videos, and he's a filmmaker, my son. So she gave him a box, and he took that box home, and then he looked at the various videos in which what my father did was captured. Of course, he knew the outline, but then he recreated this in the movie that he made. The movie is called Exorcist of Apartheid. And the reason why he chose that title is that my father was very much part of the Afrikaans church, was very much part of the establishment. And then within this church, he then came as a new voice. Although he was the leader of the church, he came as a new voice together with others. But they said, we need to change. We need to end apartheid. And we need to move the church, because the church was seen as the old government, the National Party government, at prayer. And they said they need to move. So it was the underlying idea was for the country to change, we need a change of heart, because the government is not just by its own going to surrender power. They would have to believe differently. And so then they, in 1982, my father was voted out as the head of the church. And then he came back in 86 as to be the head of the church. It was the time of the state of emergency and sanctions and all of that. And so they brought him back, and then they declared apartheid a heresy and a sin. And then he received all kinds of threats because he was seen as selling out the government, the white government. And he, especially from the right wing, there was a group that came to our house. I wasn't living there anymore, but to our house, and they met with him. They said they want to come and discuss with him, but when they met with him, they put a curse on him and left. And then a number of threats. And then later on, just actually the year of the elections, which was 94, he was then retired. But then one evening he was sitting at home with my brother's children watching television, and somebody shot him through the window. And so this story then covers this history, and it starts with a nice shot, I think, of a sermon that he gave as the head of the church to white Afrikaans members of the congregation, and said, we will have to change. So somehow that was captured on video. And then from that sermon, there's a flashback and there's a flash forward and so forth that tells this whole story of how somebody using the access that one has through the church and through being a leader in the community to actually bring change from inside. So there were many others who brought important change from the outside, but I think what that story tells quite well is how one can also, in some cases, have agents who are within the system who then also bring about change. And that's a complex story because on the one hand, you are part of the system. And so in a way, you carry some responsibility for it. But on the other hand, you also take it forward. And in some cases, you pay the price for that.
Many thanks, Christoph, for sharing this very personal and touching story of your father through the eyes of your son and this documentary, which I think is fascinating. And this storytelling and making sometimes perhaps abstract or dry topics very lively and real, I think that has been also very much part and parcel of the approach of peer-to-peer learning, which is something that in the Office of the High Commissioner for Human Rights with faith-based actors, we have been piloting with the Faith for Rights Toolkit. So a question to Ibrahim about this toolkit. What have been your experiences since it was launched in January earlier this year, especially in the current COVID-19 context? Any lessons learned from your perspective?
Michael, I'm sorry, can I just say that the judges are deliberating and they're asking whether I can join them there. Would you mind if
Of course, please join them. And I also give a warning to all the other participants, including the finalists. So please already take a moment to ask a question to Ibrahim, and after he has just replied. But please, Christoph, go back to the judges.
I wanted to say before answering directly your question, Michael, that the story in the story is fascinating. It is unbelievable how this non-accidental coincidence that Christopher's son is a filmmaker, I find it to be grounded in a historical predetermination. It must have been the prayers of the grandfather that made the grandson a filmmaker who would take this box and show us. And here I start the human rights reading of the fascinating story in the story. The human rights reading is that we all have responsibilities, and that you don't have to be a human rights lawyer or not at all use the human rights jargon. You can be wherever you are, an influential member of the society, a member of your own family, a son, a daughter, and whatever you say or you do, it might take generations, as in the case of this story. But then it sets a new direction altogether. The Faith for Rights Toolkit is precisely about how to learn and convey the human rights responsibilities of religious leaders and faith actors. And this story that traveled decades between the father of Christoph Haynes through his grandson to us, to the toolkit, is a fascinating, concrete example of how life is not made by lawyers and how justice can be and should be defended by everybody. And I think this should humble us. And humbleness is at the heart of the toolkit because it's about peer-to-peer learning. What I learned, to directly answer your question, Michael, and you have been part and parcel of all this experience from the beginning, is that the more you are genuinely humble and listening to people's experience, the more together with them, you reach a new horizon that none of you would have even thought about before this exercise started. The exercise of peer-to-peer learning is about sharing experiences. And it's also at the heart, to link it with your first question, it's at the heart of the necessary adaptation and reconciliation when rights are in tension and this happens every day. It's only clear-cut in the legalistic minds of the idealistical preachers of more, or rights. Yes, how? At times, things are very complicated. Your deliberations show it. So in addition to advocacy, you need to peer-to-peer learning to rebalance the moral balance between preaching for change and listening to the reality and trying to reach a common ground. So those are more or less my lessons, but I'm overwhelmed by the impact of the story. That's why I didn't elaborate exactly on your question. Thank you, Michael.
Many thanks. Are there any participants who want to take the floor, ask a question or make a comment? I also have one question in the chat box. And just to warn you, if you don't have any questions, I have a question to you. So I may go to Mariam, Sydney, Eugene, or Martin, or anyone else. So you thought you were done after your pleadings, but I think now the real pleading counts. So if you don't have if you don't want to ask anything orally, there's one question in the chat saying, Ibrahim, what is the threshold under the Rabat plan of action between hate speech and free speech? And I see in 3 minutes, the judges are supposed to return. So I think you're off the hook as participants, but you're not off the hook.
No, the threshold, there is a 6 threshold test, which should be applied on a case-by-case basis. Who is speaking? Speaking to who? In which kind of authority and with which means? And what's the probable impact and what's the motivation? With these criteria, and I don't have the time to give examples, the same substance, the same statement can fall or not fall under incitement to hatred, depending on all these variables. And I think it's a criteria that looks legal, but it's also applicable by ordinary people in their own lives. I mean, it was, I think, a Chinese proverb that says, if it's not kind, true, and useful, don't say it. It's more or less in 3 words. Somebody, some wise mind in his or her wisdom captured the same thing. So we're trying to offer it again as a bridge between Article 19 and 20, but there is a lot of ideological tensions between these 2 articles. And look at what's happening in France these days, for example. The public debate is fascinating because it says how much politics and ideological perceptions can add to the tensions between rights, even unnecessarily. But it was necessary in this case to come with this threshold. Over to you.
And Eugene has just a follow-up question, which I just, for the sake of time, read out. Are these criteria conjunctive, or can each element be applied on its own to prove hate speech? And just a quick answer. For the threshold of Article 20, it is basically cumulative. So all the 6 parts need to be fulfilled in order to reach the high threshold of Article 20 for criminalization. However, it may be slightly different and less stringent when it comes to actions by social media companies, for example.
Hey, Michael, I think you might have frozen off here. Michael?
Have returned, and in the
okay, I'm sorry. I think I think you had frozen for a bit, but thank you so much, Michael, Ibrahim, and Professor Haynes for that very brief peer-to-peer discussion. So, with no further ado, I believe that the judges are back in the session, and they will now give their remarks to you, participants. Then we'll move directly into the announcement. So I'll leave this to you, Judge Pangalangan.
Thank you so much, Eduardo. At this stage of the proceedings, I will now ask my colleagues on the panel to give some feedback and some advice to the participants. I will go in no particular order. I'm just looking at my screen right now, and the first person at the arrangement here on my screen is Veronica. So I have Veronica, I have Christoph, Ivana, and then Manfred in that sequence.
Thank you very much. First, congratulations for a great session. We were treated as judges of the court to, I think, excellent performances by the oralists. I think the delivery in all cases was excellent. It was really very good. And there was also, I think, a very consistent and deep research of jurisprudential elements and standards in the presentations. Sometimes it's also difficult to find a balance between the scholarship in the presentation and the persuasiveness of the argument. So if I had to leave you with a piece of advice for the future, although it's absolutely clear that the four of you have very, very promising careers in front of you and the opportunity to make an important contribution in terms of the protection and promotion of human rights worldwide. But if I had to leave you a piece of advice, it would be trying to strike that balance between scholarship, but argument and persuasiveness. And in topics as fundamental and close to everyday life of people, such as access to food, access to education, the right of peaceful assembly, the environment, access to justice, etc., etc. These are issues that touch upon fundamental rights, and rights are very close to everyday life, even when we're addressing matters that have to do with new technologies and the impact on the enjoyment of human rights. So again, many congratulations to both teams and to the four oralists.
Thank you so much, Veronica. May I ask Christoph to address the participants?
Yes, thank you very much. And may I take the opportunity also just to congratulate all the participants, those who participated, as Frans Verlinden also always talks about it, in the bottom of the pyramid, and then coming up through the rounds and then participating online in the oral rounds. And then, of course, today. This is really encouraging to see how young people do live up to the occasion. And then we just see a very good sample of the talent that is on display. And I must say, it was certainly, like Veronica, I was impressed by the very good presentations that we had today, the ability to answer questions. I think it's clear that you know the facts very well because you've gone through the sort of pyramid, but also then the test is how you respond to the interaction during the rounds, and I think you did extremely well. I was also impressed, as we discussed during the break, by the references to many soft law instruments, because many of the treaties, in a way, set a basic principles and basic standards, but to amend treaties and to keep up with the change in technology, that's very difficult. And that's where I think increasingly the so-called soft law instruments become important. And so I was impressed by the way in which you were able to draw on special rapporteur reports, on general comments of various treaty bodies and so forth. I was also impressed by the references to various regional systems and their jurisprudence, so that sometimes people think about international law as one section and regional law as something else. But I think certainly we're moving more towards seeing international law as the global element and the regional element. And I think you demonstrated that. The references to the record, to say this particular paragraph, or to cases and that particular paragraph, those things are always impressive. So very well done. I would say that I think it's important to also perhaps just emphasize that how important it is when you ask questions to answer the specific question that you asked. So I know in many cases one has you have to be able to think on your feet, but I think in one or two cases it may be the question went in one direction and the answer went a little bit in the other direction. And I think it's also, when soft law is quoted, it's important to quote the most recent one. So if there's an earlier one 4 years ago, whatever the case may be, but in the meantime, it has been updated, then it's of course more powerful to quote the later one. But I think it went very well. I was really impressed by the presentations we saw today. Thank you very much for that.
Thank you very much, Christoph. Ivana?
Thank you, Raul. First of all, I would like to say that I'm very, very much honored, and it's my great pleasure to be a part of this judicial panel on a final round. I'm impressed, as well as my colleagues, with the quality of presentations, with the oralists' ability to address and to show that they actually were very well prepared. And I imagine the amount of time and energy invested in research, and I congratulate you on that. What I would like to emphasize also is that it is not easy, even before the court hearing, to address always rightly the question, or maybe to rightly address what was in the mind of a judge asking particular question. But my advice for you would be always to invoke jurisprudence of international courts, or use concluding observations, but views and general comments of the treaty bodies of the United Nations system. That is always helpful. And I think that you managed, all of you, to use this machinery in an impressive manner. Sometimes I also felt like some questions were not fully replied, but then this is also maybe because of the way of today's final round, which is not usual because of COVID and because of actually distance that we have. So all in all, I am really impressed also with organization. This is a huge event, and the organization, as far as I could see, is impeccable. And I congratulate to both the organizers and participants.
Thank you very much, Ivana. And then Manfred?
Yes, I would like to share, of course, the comments of my colleagues on the bench. First of all, I would like to congratulate the whole team that organized this moot court. It's really a challenge to do that in times of COVID, purely online. I would also like to congratulate Zoom. We really didn't have any major technical problems. So that it really worked very well. The third one is to those who were drafting the case. I think I have never probably seen any other case that was that difficult and complex. I mean, you kind of put in all the most controversial questions that we are discussing in international and regional human rights issues. They were all somehow involved, and that means, of course, that it was a very high threshold for all the teams who participated. Perhaps on the case in the future, if you could use a little bit less acronyms, it would be great, because I always had, again, to look back and forward what these acronyms actually mean. Yeah, I think to the final round now, I again am extremely impressed by all four oralists, by both teams. If I would have four highly qualified legal jobs in the global campus of human rights to offer, I would hire all four of you. I think it was such a pleasure to listening to your to your arguments, the way how you brought forward the case, but also the way how you responded to the questions. Of course, not all the questions of the judges were really addressed, or partly you evaded a little bit, but that's of course the reality, because some of those questions were also not easy to be answered. I was also very much impressed by this 1 minute rebuttal. I think in 1 minute to really address what I also considered were the most important issues that were brought up by the respondents. So I I must say this. I felt that both teams were excellent, and for us it is a very difficult decision to really finally have to decide on the winning team. Thank you.
Thank you very much, Manfred. Well, Judge Nowak mentioned that this is a very complicated case, and I agree 100%. I have been involved in moot courts since I took part in the Jessup as a student decades ago, and this case problem, I think, takes the cake. It's a record breaker in terms of the complicated fact situation and all the overlays of different kinds of issues from different directions. I congratulate all the participants. Taking part in a very prestigious moot court competition is a feather in the cap for all of you. It will help you in your careers, in your applications for jobs, for judicial clerkships, for LLM programs, for scholarships. My one piece of advice is that it has been mentioned also by my colleagues that it is good that you have a solid grasp of the law and of the cases in this field, which you both teams ably demonstrated. But on top of that, you need some sort of, like, for lack of a better word, courtroom presence. You are advocates. You are supposed, it's good that you have all these laws that you can cite, but you have to marshal them as advocates to be effective, to convince a set of judges to rule in favor of the position that you espouse. And that is a skill that that is very valuable. That is a skill for which counsel, for which lawyers are valued by courts and by clients. And I do hope you, in the course of your careers, that you sustain your interest in the human rights values that this moot court competition aims to memorialize and to institutionalize. On that point, let me ask Eduardo what we should do next.
Thank you, Judge. Thank you, judges, and also congratulations again to both teams. And at this stage, I will turn over to Professor Feliun, who will make the announcement of the winners and then conclude the session.
Thank you very much, Eduardo. And thank you very much again to our judges. I think let's keep the suspense for a moment longer. Let me just celebrate the diversity that our judges brought. We were representing the three regional systems. Obviously, Judge Jelić brought the European Court of Human Rights experience. We had Veronica, who was not only, in a sense, representing the global campus of human rights, but also her experience within the Inter-American system, in the Inter-American Commission. And Christoph, Professor Christoph Heyns, obviously mixing his UN experience also with the African experience, among others, as a member of the working group of the African Commission on Human and People's Rights. So I think that's wonderful that the three regional systems were represented, but overlapping with the very significant experience of Judge Pangalangan from the International Criminal Court, and then Professor Manfred Nowak Global Campus, and so much more, including his experience in various capacities within the United Nations. So once again, thank you so much for making the time, for struggling through the very complex set of facts. And I think it was a wonderful session, and the students and the participants obviously benefited greatly. So thank you to the presiding judge and the 4 members of the panel. We really appreciate your time and assistance. Let me just say that we have also the support of the University of Lucerne. In the past, our winners were granted the opportunity to attend a course, a human rights course, related course. That had not happened in 2020 for the previous year's winners. So we are in the process of negotiating, but we trust that that will be also possible for our winners. So just acknowledging the University of Lucerne's contributions in the past, and we hope going into the future. Again, let me just say we hope to see all of you, the faculties, at least at the Moot competition next year. If I had the dates maybe wrong, I want to say the date should be 12 to 16 July. 12 to 16 July for anyone who wants to put that already in their calendars for 2021. The unanimous view of the 5 judge panel is that the applicant team, team number 5, which is Strathmore University, is the winner of the 2020 Nelson Mandela World Human Rights Moot Court competition. So our congratulations to Strathmore University and the respondents, also for the information of the judges who had not been privy to the identity of the teams. The respondent team is Kenyatta University. So by a strange twist of fate, after all these different universities participated, the 2 teams in the final round were actually from the same country, as you can gather. That was very surprising, very peculiar. I think it was a peculiar and extraordinary year, an extraordinary event, and I suppose it's just in the spirit of the times. So once again, congratulations, Strathmore, winners of the 2020 Nelson Mandela World Human Rights Moot Court competition. Thank you once again to everyone. If I may once again single out Eduardo, whose year, in a sense, has been consumed by organizing this moot. Thank you again, everyone. Thank you, participants. Thank you, all the faculty supporting this event. Thank you to the Global Campus of Human Rights. We hope to be in Geneva together next year. Thank you and safe day.